All rise, please. Ladies and gentlemen, the Justices of the Supreme Court of the State of Connecticut.
Morning, Mr. Marshall. Please open court.
Yes, Your Honor. Oyez, oyez, oyez. The Honorable Supreme Court, State of Connecticut is now open session in this place. All persons having cause or actually pending therein will give their attendance according to law.
Thank you.
Ladies and gentlemen, you may be seated. Good morning, Your Honors.
Good morning, ladies and gentlemen. Our only case of the day will be Connecticut Coalition for Justice and Education Funding versus M. Jody Rell et al.
May it please the Court. My name is David Noah from Jerome and Frank Legal Services at the Yale Law School, along with my co-counsel Neil Weir, on behalf of plaintiffs. I'd like to use the first 30 minutes of this argument to discuss the substantive and procedural questions under Article 8, Section 1. That is, what is the right under Article 8, and when should a full determination of that right be made? My co-counsel will use the remaining 15 minutes to discuss the issue of justiciability. We'd also like to reserve 15 minutes and also the balance of our time for rebuttal.
You're reserving 15 minutes for rebuttal.
That's right, Your Honor. 30 years ago, this court recognized that Connecticut school children have a fundamental right to education. The question before the court today is whether that right has any meaningful content. Just as there was a great deal at stake 30 years ago, there's a great deal at stake here today. When the state denies students the opportunity even to become productive and engaged citizens, that's not an education in any real sense of the word. Nonetheless, the state proposes that the principle embodied in Article 8, Section 1 has no qualitative content. The state maintains this position in spite of the fact that for the purposes of this appeal, and as plaintiffs will show at trial, the state has denied the necessary resources to provide thousands of students in plaintiff districts with any meaningful opportunity to prepare for the world beyond high school. For example, half the fourth graders in Bridgeport read at the lowest of the state's 5 levels. That's below basic, functionally illiterate, dramatically increasing the likelihood that as adults, they will not be able to participate in our democratic institutions. For example, in New Britain and Danbury schools, there is no remedial instruction, so that by middle school, students are completely unable to engage in the curriculum in their classrooms. For example, where in Hartford and several other plaintiff districts, more than half the entering 9th graders do not graduate, dramatically limiting, if not eliminating, their ability to obtain meaningful employment to support themselves and their families. To accept the state's position, this court has to accept that an effective denial of education is consistent with the views of the framers in 1965 and is consistent with the views of this court when it said the right to education was fundamental. Further, to affirm the trial court's decision will be a stark departure from the 350-year recognition of the state's duty towards public education, and would set Connecticut apart as the only state to have examined its right to education and concluded that it has no qualitative content.
Excuse me, counsel, one question. You seem to be addressing this issue as though it was a decision on the merits of a case, and I wonder if you're going to discuss whether the claim can survive the motion to strike and what the nature of the trial court's view, based on the Geyser factor, should have been at that point.
Absolutely, Your Honor. I think the trial court's holding, although it wasn't entirely clear, was that there was no right to suitable educational opportunities as we define them. Now, the state seems to have asserted 2 positions in their brief. First, that there is no qualitative content whatsoever, and second, that even if there was some qualitative content, it's not what plaintiffs claim that it is.
Okay, and you take this approach because while there's lots of factual allegations about a violation of Article 8, Section 1, it's basically a legal conclusion that's alleged as to the content of it. And therefore, are you accepting the concept that the trial court had to address that legal issue on the merits at that point? using a Geisler analysis?
What we're arguing, Your Honor, is that the trial court, first of all, prematurely determined the full scope of the right, that there is no right to suitable educational opportunities, while apparently at the same time recognizing that there is some qualitative content to Article 8. We believe the decision to really close the door on the right, say that we can determine the full scope now without a single fact on the record, that was premature, especially considering certain Geisler cases where under the fifth and the sixth factors, that's history and public policy, this court has actually used facts as part of its determination. I would specifically point the court to Moore v. Ganem and also to Benjamin v. Bailey, where this court did consider facts in its determination of the actual right itself. And so I think there's 2 points there. It's first, of course, it is a legal question whether there's some qualitative content. If there's no qualitative content, then of course plaintiffs fail. But if there is, in fact...
Do you cite the Moore case and the other that you cited for the principle that you don't need a factual basis for the Geisler analysis?
No, I'm sorry, Your Honor. I was citing it to say that the court has, in fact, considered facts as part of the Geisler analysis, specifically under the last factor.
I see.
Well, this was, by the trial court, the most preliminary gatekeeping function, right? Looking at the complaint via a motion to strike. And all facts obviously had to be interpreted in favor of the plaintiffs, but not legal conclusions.
And certainly, insofar as this court is prepared to grant every possible fact, including some of the facts that seem to be disputed by defendants, we certainly can proceed to the merits. And really the question on the merits, it seems, is whether plaintiffs' claims match up with the right as it exists in Article 8, Section 1. And to clarify exactly what plaintiffs' claims are in the complaint, first, what plaintiffs are claiming is a constitutional minimum floor. Really, as a logical matter, an affirmative right can only be a minimum right. And so, of course, we are claiming a constitutional minimum. Now, in paragraph 46 of the complaint, and also in paragraphs 2 through 4, it's page 17 in the complaint, it's also page 2 of the complaint. That's paragraphs 2 through 4 and paragraph 46. Plaintiffs are extremely clear about how they're defining the right. The right is defined as an education that gives students the opportunity to function as citizens and either to find gainful employment or to move on to higher education. That is how they define the right. That is the claim. Now, it seems that the trial court also included in the constitutional claim paragraph 53, which is in fact in the next section. So section 2 of the complaint is a section about the definition of the constitutional right. Part 3 of the complaint is about the inputs the state is denying as a factual matter that are related to those purposes. Now, to be absolutely clear, paragraph 53 of the complaint, and that list of inputs, is simply a template of what plaintiffs plan to show at trial as far as what is necessary in the modern context to achieve the purposes laid out in paragraph 46.
But do you concede that a Geisler analysis was proper on some basis at this stage in order to assess the legal claim presented?
Yes, absolutely, Your Honor. We certainly concede that.
But is it that it should have been a gatekeeping type of look, a threshold look to see whether, if a look at Geisler indicated that the plaintiffs had a viable claim, even though it wasn't getting into the merits and deciding whether it succeeded or not? Is that the essence of your claim?
That's basically the essence, is that the court should have used the Geisler analysis to, of course, examine the nature of the right. Certainly the first 4 Geisler factors are purely legal. Even history, to a great extent, is legal, although I would point to the amicus brief filed by Professor Collier and also by Judge Bernstein to say that there is, in fact, a great amount of historical evidence that is not simply a question of law. But certainly the first 4 factors are purely legal. Now, the 5th and 6th factor, rather, maybe mixed questions of law and fact. But yes, a Geisler analysis was appropriate in as sort of a gatekeeping function to see if the claim had any overlap with